webinar, UCC Perfection Perils, Managing the Risk of Post-Filing Debtor and Collateral Changes. My name is Anu Shaw and I will be your moderator. Joining us today is Paul Hodnefield. Paul is Associate General Counsel for Corporation Service Company and serves as the company's subject matter resource for UCC, real estate, and other transactional service matters. He is a frequent speaker and writer on UCC search and filing issues, and a 2013 recipient of National Association of Secretaries of State Medallion Award. And with that, let's welcome Paul.
Thank you. Some of the most confusing aspects of the perfection process under Article 9 actually occur after a secured party has filed its financing statement. A number of different events can occur after that time that require the secured party to file additional UCC records or take other action. And the failure of the secured party to act promptly in those situations can leave that secured party unperfected, at least with respect to some or sometimes even all of the collateral. Now, understanding the significance of different post-closing events and the actions required by the secured party in response can be a real challenge. Even the courts have struggled with these issues. And sometimes even the courts don't arrive at the correct answer. So what my goal today is to give you a better understanding of what post-filing events require action by the secured party, what the secured party must do to remain perfected, and along the way I'll identify traps for the unwary at every step of the process. And the way I'm going to do this is beginning by providing an introduction, an overview to why this is such an issue. And then I'll move on and talk about the specific events that create the greatest risk for secured parties and how to manage them. And those are the debtor name change, a new debtor becoming bound by the security agreement, a change in the governing law affecting perfection and priority, and the transfer of collateral. And at the end, there will be some time for questions and answers, and I'll also respond to offline questions that come in later as well. But let me go ahead and start with some of the preliminary concepts it's important to understand about these issues. The first is, what post-closing changes do to a perfected security interest. As a threshold issue, it's important to understand that not every post-closing change involving a debtor or collateral or secured party require action in order for the secured party to remain perfected. But for the particular changes I'm going to talk about today, they do place the secured party at risk of losing perfection with respect to some or all of the collateral. So it is a very important high-stakes issue. And these are complex issues, as I said. It's not, the answers to these issues and the questions that arise are not found necessarily in one spot in Article 9. It's not something where you can turn to Section X and there is the answer for that particular item. Oftentimes it requires traveling through the code kind of on a scavenger hunt from one section to the next section and on down the line until all of these can be found. As I said, even the courts struggle with these issues. They get lost in the process, and there have been some very interesting decisions as a result. I'll talk about one or two of them today. And because these are so complex, I always think it's a good idea to consult with legal counsel whenever these certain post-closing issues arise. One other thing I can add here too is for better understanding what is required and which sections of Article 9 are implicated, it's a good idea to have a copy of Article 9 that includes the official comments, because the official comments will identify other sections that may be applicable to the issues that arise. And it's really important to get this right, and that's because there's very little wiggle room for the secured party. The courts and the UCC code itself are unforgiving of noncompliance. Secured parties can't even use lack of knowledge as an excuse for failing to act when Article 9 requires some sort of action. The secured party is the beneficiary of the security interest, is expected to monitor and keep track of the of post-closing changes and to take action whenever it's required, even if the debtor doesn't tell the secured party when one of these events has occurred. So again, the stakes are high, the risks are high, and secured parties therefore have to be extra diligent. So with all that said, let me move on and talk about probably the most common post-closing change that should be of concern for a secured party, and that is the debtor name change. This happens very commonly. Well, what exactly is a debtor name change? Well, it depends on the type of debtor involved, and we're talking about a name change so that the name required by UCC Section 9503A changes, not that a trade name changes or some other inconsequential change, but rather if the name that's required for purposes of the financing statement changes, that's when a secured party has to take action. Well, when exactly does this occur? If it's a registered organization, the name changes only by the filing of a public record. A registered organization's name will change only when the public organic record is amended to change the name. An amendment to the Articles of Incorporation or an amendment to the Articles of Organization, if that restates the name or changes or restates the name. For other types of registered organizations, it might be a change in the, for a business trust, for example, it might be a change in the, an amendment to the declaration of trust that might get filed with a state, or it might be a change in legislation if it's a registered organization created by legislation. So there will be a public record trail there. For other types of organizations, it may be a little bit more difficult to determine when a name changes because they may not have a public record that states the name. The code says that if it's a trust, for example, if the collateral is held in trust, then the name of the debtor is the name of the trust if it has a name, or the name of the settlor. So a secured party has to monitor the name of the settlor if that could change, and the name of the trust, and that isn't going to be changed through a public record document. It's going to be changed through an amendment to the declaration of trust or the trust agreement, whatever created that trust, the organic document of the trust. So it's important to stay in contact with the debtor and identify any changes along that line. Other types of organizations that they may change by a general partnership agreement or something like that if that's amended to change the name. It won't be part of the public record, but it still may be a name change. If the debtor is an individual, in most states since 2013, the starting point is the driver's license or in some cases state-issued ID card. If the name is displayed on that driver's license or ID card changes, or if that document expires, or if the debtor moves to a different state, all of those events can be a name change event and require action by the secured party. Other types of changes may or may not. It depends on whether or not the debtor has an unexpired driver's license issued by the state of filing. But we're going to assume for purposes of this discussion that any debtor does have an unexpired driver's license issued by the state of where the financing statement will be filed. And so it would be a change to the driver's license that would create the name change for purposes of Article 9. So just because a name changes doesn't necessarily mean that the secured party has to take action. The first step is to determine whether the name change makes a filed financing statement seriously misleading. In other words, would a search of the new name disclose a financing statement filed under the old name? Under Section 9507, before we get to 507, first of all, the general rule is that a financing statement sufficiently provides the name of the debtor if it complies with Section 9503A. If it doesn't comply strictly with 9503A, I mean, even a comma out of place means it's not 9503A, then it makes financing statements seriously misleading under Section 9506B, and a seriously misleading financing statement is not effective. So any deviation, no matter how slight, makes the name insufficient, and an insufficient name will make the record seriously misleading and ineffective, with one exception, and that is if a search of the correct debtor name using the jurisdiction standard search logic would disclose the financing statement that fails to sufficiently provide the debtor name, then that insufficient debtor name doesn't make the record seriously misleading. So really we have two standards here. It either strictly complies with the name requirement, or it shows up on a search of the name that strictly complies with the name requirement. Now, search logic really isn't very flexible in most states. It will compensate somewhat for minor deviations in spacing and punctuation and things, but it generally doesn't compensate for any substantive deviation or typos or misspellings and that type of thing. Now, determining whether a debtor name change has made a financing statement seriously misleading typically is going to involve a 9506C search. So if the name complied with 9503A before the name change, and it continues to show up on a 9506C search, in other words, a search of the correct debtor name using the jurisdiction standard search logic, then if the old name is disclosed under a search of the new name, no problem. If it isn't disclosed, then the secured party must take action. Although, arguably, even if it shows up, the secured party should take some action at some point. That's because no secured party should ever rely on a jurisdiction standard search logic to keep it perfected following a change in the debtor name, and the reason is that search logic can and does change. A state can change its search logic, and if the standard search logic changes in a way that a non-sufficient name no longer shows up, arguably that's the secured party's responsibility, and secured party will become unperfected. So the best practice, no matter how slight the name change, the best practice is to still file an amendment to change the name. And it's important to make sure the correct name is on there because of the way that Section 9507 actually works. 9507 determines the effect of a debtor name change, what it does to the secured party's perfection. So if the debtor so changes its name that a filed financing statement becomes seriously misleading, then what happens is, first of all, the financing statement will remain effective to perfect the security interest for collateral acquired by the debtor before and within 4 months after the name change. So it's not the end of the world usually if the debtor changes its name and the secured party doesn't find out right away, because the secured party is going to remain perfected in that existing collateral. It's the after acquired collateral that's more of a problem. The secured party will become unperfected for collateral acquired more than 4 months after the name change, unless an amendment is filed to add the new name to the financing statement within that 4-month period. If it's not filed within that 4-month period, the secured party becomes unperfected. So really we've got different scenarios that can play out here. If the secured party doesn't become aware of the name change and doesn't file in time. So really, here's the way it can actually play out. And this, again, is looking at after acquired collateral. If the debtor changes its name on March 1st and the secured party doesn't file a name change amendment by July 1st, the secured party will become unperfected in after acquired collateral by July 1st, or on July 1st. If the secured party, however, becomes aware of the name change within that 4-month period and files anytime before July 1st to amend the financing statement and add the name, the new name, then perfection will continue beyond that 4-month window in the after acquired collateral. There will be no gap in perfection or anything along that line. And there's also the situation where the secured party doesn't learn about the transaction until more than 4 months after the name change and then files a financing statement or an amendment to add the debtor name more than 4 months after. So what happens in that situation for the after-acquired collateral, the secured party, because they don't file by July 1st, is going to become unperfected in this hypo. But when they refile the financing statement on, let's say, November 1st, then they will become perfected again, and they will be perfected in that after-acquired collateral. However, because they were unperfected, they will only become reperfected with a priority date in that after-acquired collateral beginning on the date the amendment was filed. So anything other than filing an amendment before that 4 months expires after the name change is very risky for the secured party. So the best practices following a debtor name change, the first step is amend the financing statement. That means filing an amendment to make sure that the financing statement is not seriously misleading under 9507C, and that amendment must change or add the name of the new debtor. I typically recommend using add to remove any confusion as to whether it's replacing the old name or adding the replacing it entirely, or whether both names are supposed to appear. So, but either a change or an add will work. There are sometimes multiple avenues to accomplish the same thing under Article 9. I also recommend, of course, this has to be done within 4 months after the debtor name changes. Once the secured party lets it go beyond 4 months, that's a problem because it will affect their priority. I also recommend anytime you amend a debtor name to do a post-filing search on the new name using the jurisdiction standard search logic on the correct name, and that helps to verify that it was correctly filed and correctly indexed. Now, there is some case law out there involving debtor name changes. I want to cover a couple of these cases. One is In Re Lifestyle Home Furnishings. The debtor's correct name was Factory Direct LLC, and the debtor borrowed money. It obtained a secured loan from Wells Fargo. Wells Fargo perfected its security interest by filing a financing statement that named Factory Direct LLC as the debtor. 3 years later, Factory Direct amended its articles of organization to change its name. The new name stated in the amended articles was Lifestyle Home Furnishings LLC. Now, because of the difference in the two names, of course, the financing statement was rendered seriously misleading. Wells Fargo didn't file any new financing statements or amend the existing financing statement to reflect the new name. And a few years later, Lifestyle filed for bankruptcy. So at that point, the trustee saw that the security interest or that the financing statement had not been amended, and the trustee sought to avoid Wells Fargo's security interest for any of the collateral acquired by the debtor more than 4 months after that name change 3 years earlier. And in this case, the court found in favor of the trustee because Wells Fargo did not take the action required by 9507C within 4 months of the name change. It was not even a close call. Wells Fargo really didn't even contest it. They did challenge on some other grounds but didn't prevail there either. So the secured party was not perfected as a result of that. Another case dealing with a name change was Broyhill Furniture. Broyhill Furniture versus Hudson Furniture Galleries. What happened here was that the debtor's original name was IFR Hudson Valley LLC. And in 2003, the debtor took out a secured loan with its bank. The bank promptly perfected its security interest in nearly all the debtor's assets. It filed a financing statement to perfect that security interest right away, and the name on there was IFR Hudson Valley LLC as debtor. A few months later, in October 2003, the debtor agreed to buy merchandise from Broyhill, a manufacturer, on credit, and it granted Broyhill a security interest in the goods it purchased. And then a month after that, the debtor changed its name to Hudson Furniture Galleries by amending its articles on file with the Secretary of State. Now, Hudson Furniture Galleries was sufficiently different from IRF Hudson Valley to make the financing statement seriously misleading. Now, Broyhill had not properly perfected a purchase money security interest, but it did learn of the name change within that 4-month period. It conducted a UCC search, didn't see any financing statements under the new name, so it went ahead and filed its own financing statement on February 17, 2004. The bank, however, did not amend its financing statement to reflect its new name. Later, the debtor ran into financial difficulties and held a going out of business sale. It liquidated all of the merchandise, and then the debtor paid all of the proceeds over to the bank, including proceeds of the sale of the Broyhill collateral. Well, Broyhill brought an action against the bank seeking to recover those proceeds. The bank argued that Broyhill's security interest was subordinate to its security interest because Broyhill failed to properly perfect a purchase money security interest. However, the court found that despite Broyhill's failure to comply with the purchase money requirements, it still had priority from the date it filed its financing statement. And the bank, because it never amended its financing statement, became unperfected in any of that after-acquired collateral. Actually, even though Broyhill might have had actual knowledge of the debtor's name change, and that didn't matter. Even if Broyhill knew of the prior security interest, it didn't matter, because in the case of the bank, the court noted that a creditor's actual knowledge of the debtor's name change or the fact that another creditor exists does not relieve the secured party of its duty to refile or amend the financing statement. Consequently, the bank was unperfected in collateral delivered by Broyhill more than 4 months after the name change, and it lost the suit and had to pay over the proceeds. So the things to take away from these cases are, first of all, the courts do hold secured parties strictly accountable for complying with the requirements, even if they don't have knowledge of the name change. Another thing to take away from this case is that while there may be some relief in knowing that existing collateral remains perfected, oftentimes the biggest assets of the debtor are going to be accounts and inventory, and accounts turn over on a regular basis. So more than 4 months after that name change, there's a very good chance that a lot of accounts are going to start turning over, and the new accounts created are not going to the secured party won't be perfected in those. So that can be a serious issue. Same thing with inventory, as happened in Broyhill. So it is important for secured parties to track debtor name changes, pay close attention, and take prompt action upon learning of any type of debtor name change. The second type of post-closing event of greatest concern is when a new debtor becomes bound by the security agreement. This can happen in a number of different situations. An acquisition, for example, where one company acquires another. When they do that, they become bound by security interests that were, or security agreements entered into by the target of the acquisition. Same thing can happen in a merger. The surviving entity typically will be bound by the security agreements entered into by the merged entity. A change in structure. For example, if a sole proprietor incorporates or forms an LLC, that may very well remain bound by that security agreement entered into by the sole proprietor. And there may be a voluntary assumption. Sometimes a company will make a transaction where one company agrees to succeed to the debts of another company. Well, when these types of events happen, then UCC Section 9508 comes into play. And if the name of the new debtor is sufficiently different from the name of the original debtor that a filed financing statement becomes seriously misleading, then it's a situation where Section 9508 will determine the status of the security interest with respect to existing and after-acquired collateral. The rule for existing collateral, if the name change or if the new debtor's name makes the financing statement seriously misleading, The financing statement will nevertheless remain effective to perfect the security interest and collateral acquired before or within 4 months after the new debtor becomes bound. Again, the same issue as with a debtor name change, pretty much. When it comes to the after acquired collateral, a similar rule as well. The financing statement naming the original debtor is not effective to perfect the security interest and collateral acquired more than 4 months after the new debtor becomes bound by the security agreement. There is an exception here, and that is if the secured party files an initial financing statement naming the new debtor. Now, I emphasized here initial financing statement. That is the language of 9508. It would appear from 9508 that a simple amendment would not be sufficient, but I'll come back to that in a minute. First of all, what effect does this have on priority? Unlike a strict debtor name change, a new debtor becoming bound by the security agreement may affect the original debtor's secured party's security interest with respect to priority, because the security interest in the after acquired collateral in the original debtor may become subordinated to a security interest that was created by the new debtor before the new debtor became bound by the security interest. So that is a risk. There isn't much that a secured party to the original debtor can do about that. Now, when it comes to filing an initial financing statement, remember I said that the secured party can remain perfected in the after acquired collateral by filing an initial financing statement. The use of that term initial financing statement suggests that an amendment would not be sufficient for the secured party to remain perfected. There is, however, an official comment in Section 9512 that states an amendment to add the debtor name would satisfy the requirement of an initial financing statement. It would constitute an initial financing statement. The emphasis here is on add because an amendment to change may not have the same result. Because a change replaces the debtor, it doesn't add the debtor, and it may not be considered an initial financing statement. So I don't recommend filing a name change amendment. I recommend only filing an amendment to add the debtor or an initial financing statement. So I think the best practice when a new debtor becomes bound is, first of all, file a new financing statement, an initial financing statement naming the new debtor. It must be filed before or within 4 months after the new debtor becomes bound. Ideally, you want to get it in before the new debtor becomes bound to avoid the risk of subordination of the security interest in after acquired collateral. And a secured party can also consider filing an amendment to add the new debtor. Comment in Section 9512. There haven't been any court cases addressing the sufficiency of that, and the courts don't always have the official comments right in front of them, so that's up to the secured party to determine whether or not they want to take that course of action. I also recommend keeping the original financing statement active just to preserve evidence of the original perfection and priority date. Don't allow it to lapse. And because the financing statement is a new financing statement or adding a name of a new debtor, I recommend conducting a search to reflect after filing the financing statement, a search conducted on the correct name of the debtor to verify that it discloses the financing statement. So that's what happens when a new debtor becomes bound by the security agreement. That can get somewhat complicated. Again, sometimes it's best to consult with legal counsel to verify the best course of action in those types of situations. Another change that requires action by the secured party and can be somewhat complex is a change in the governing law. What this refers to is a change in the law governing perfection and priority under Article 9. The general rule is that the law of the jurisdiction where the debtor is located governs perfection and priority of a security interest or agricultural lien. If that law changes, and this is going to happen when either the debtor moves or the collateral is transferred to a person where located in a different jurisdiction, such that the law governing the perfection and priority is now the law of a different state. If that happens, there's a change in the governing law, and that's going to trigger action by the secured party. Here's examples of some events that can trigger a change in the governing law. If a registered organization redomesticates into a new state, and that state's law provides that the redomesticated entity is a continuation of the original entity from the other state, then that would be a change in the governing law. For other types of organizations that are not registered organizations, if they relocate their place of business, or if they have more than one place of business, their chief executive office, if they move that across state lines, that would be a change in the governing law. If an individual moves his or her principal residence across state lines, that constitutes a change in the governing law. If a new debtor becomes bound by the security agreement and is located in a different state, let's say a Minnesota corporation merges into a Delaware LLC and is merged out of existence, the Delaware LLC being the survivor, that's going to trigger a change in the governing law. And if the collateral is transferred to a transferee who resides in a different state under Article 9, Section 9307, that can be a change in the governing law. There are some things that aren't a change in the governing law. For example, let's say a Delaware corporation moves its headquarters from Illinois to Seattle. In that type of situation, they have not redomesticated. Their formation documents still reside in Delaware. There hasn't been a change in the governing law. Similarly, let's say a person who has lives in New Jersey but never got around to changing their old New York driver's license that they were issued 7 years ago. When they go and get a New Jersey license, that doesn't trigger a change in the governing law because the license doesn't determine it. It's the principal residence. So what is the effect of change in the governing law on existing collateral? And what does the secured party have to do to remain perfected? Well, it depends on the nature of the change in the governing law. If it's a simple relocation, in other words, let's say an individual moves from Minnesota to Wisconsin. They move their principal residence from Minnesota to Wisconsin. That's a change in the governing law, and the secured party will remain perfected for existing collateral for a period of 4 months after that change in the governing law. Unless they take action, they will cease to be perfected after 4 months. If a new debtor becomes bound and is located in another jurisdiction, the secured party may have up to a year, because of the transfer of the collateral to the new debtor, they may have up to a year to file in the new jurisdiction. Now, both of these timelines will depend upon the lapse date in the original jurisdiction. The secured party will have until the earlier of the lapse date or the 4-month or 1-year period, whichever applies to the type of change in the governing law. So after a change in the governing law, the only way the secured party can remain perfected is to file a financing statement in the new jurisdiction that provides the correct debtor name. It has to be done before the applicable deadline or before the security interest lapses in the original jurisdiction, whichever comes first. And that might be a very short period of time. Who knows? It depends on the file date of the financing statement in the original jurisdiction. Now, as far as the change in the governing law and after acquired collateral, there is now and it has been since July 1st, 2013 in most states, a 4-month grace period. Originally, until the 2010 amendments to Article 9, a secured party could become immediately unperfected and after acquired collateral following a change in the governing law. Now there's a 4-month grace period. The secured party has 4 months in which to file new jurisdiction to remain perfected in the after acquired collateral, and that 4-month period is regardless of whether it's a simple relocation or a transfer to a new debtor who becomes bound. The secured party is going to have to file they're going to have to refile in the new jurisdiction by that deadline, the applicable deadline, to maintain that perfection in the after acquired property. Otherwise, they will become unperfected. So the best practice following a change in the governing law is to file in the new jurisdiction as soon as possible, and if at all possible, to file before the debtor relocates in such a way or other event that causes a change in the governing law. This is one where it's more important to keep a close eye on your debtor and be aware of any changes that could trigger a change in the governing law to be able to file in time. Once the financing statement is filed in the new jurisdiction, I recommend keeping the original financing statement in the old jurisdiction active to preserve evidence of perfection and priority. That's not an Article 9 requirement, but I think it's a best practice. And then, of course, conduct a UCC search in the new jurisdiction to reflect the new financing statement, search on the correct name of the debtor, and verify that it shows up on a 506C search. A couple of cases I want to mention about change in the governing law. The first is Farm Credit Services versus Wilson. What happened here, the debtors were individuals and they were residents of the state of Missouri. They were actually farmers, and the debtors financed the purchase of a planter through Farm Credit leasing. Farm Credit perfected its security interest by filing a financing statement with the Missouri Secretary of State. And then, without Farm Credit's knowledge or consent, the debtors sold the planter to a person named Wilson, who was a resident of Oklahoma. Wilson took possession of the planter and he moved it to his residence in Oklahoma. Farm Credit didn't learn about the sale until more than a year later. They did file a financing statement in Oklahoma naming Wilson as the debtor, but the debtors by that time had defaulted. Farm Credit sought to recover the planter from Wilson, and Wilson argued that Farm Credit became unperfected and didn't have a security interest to enforce against the planter because they didn't file in Oklahoma by the deadline. Well, what they did is they took a look at this and they sided with Farm Credit Leasing. They said that the lender's claim was superior to the out-of-state buyer, despite the failure to re-perfect within the 1 year required by Article 9. The court essentially said Farm Credit was properly perfected at the time of the transfer, so Wilson had constructive notice of the security interest and took subject to it. And it didn't matter in this case that Farm Credit became unperfected because it didn't extinguish the security interest. It only affected Farm Credit's priority with respect to other creditors. There were no other creditors involved, so Wilson took subject to Farm Credit's security interest, and they didn't find any reason why 9.315 shouldn't apply. And I'll touch on 9.315 here in a minute and go into more detail. Another very interesting case that shows how the courts can struggle with this is First National Bank of Picayune versus Pearl River Fabricators. What happened here was Pearl River was a Mississippi corporation, and in 2001 the bank loaned Pearl River money and in exchange took a security interest in collateral that included two pieces of specific equipment. The bank promptly perfected its security interest by filing a financing statement in Mississippi. And just a few months later, Pearl River sold the equipment to a company called Growth Fund Industries, which was an Indiana corporation. The bank did not know of or consent to that sale. 1 month after that, Growth Fund sold the equipment to Phoenix Associates, a Nevada corporation. And Phoenix then took the equipment and moved it from Mississippi to Louisiana. So we have equipment that's located in Mississippi, is owned by a Mississippi corporation, and it is sold to an Indiana corporation, which in turn resells it to a Nevada corporation, and the Nevada corporation moves the equipment from Mississippi to Louisiana. So the court had to sort all this out because more than a year after the transfer of the equipment, Pearl River defaulted on its loan, and the bank sought to enforce its security interest against the equipment and sought to enforce it against the ultimate owner of the equipment, Phoenix Associates. Now, the court appeared somewhat confused, and it seemed to focus on issues of where did the sale take place? Was it in Louisiana or Mississippi or Indiana? It also focused on the location of the equipment rather than the location of the parties involved. Well, the court held that because the secured party didn't re-perfect in Louisiana within 1 year of the transfer, that the security interest became unperfected, so it couldn't enforce it against Phoenix. The problem here is that Louisiana, under any view of the facts, is not the proper place to file because none of the debtors were located in Louisiana, and the equipment was not of the type where you file where the equipment's located. So the court got it completely wrong in that one. And that just goes to illustrate some of the challenges the courts run into, and if the courts have trouble sorting it out, so do secured parties. So that's why I do recommend consulting with legal counsel when these issues arise. Another issue that I want to talk about is, or another post-closing event, is the transfer of collateral. This is related kind of to that case. Transfer of collateral, ordinarily, a security interest follows the collateral. Under Section 9315A, a security interest continues in collateral notwithstanding the sale, lease, license, exchange, or other disposition unless the secured party authorizes the disposition free of the security interest. Now, there is an exception to that in Section 9320, and that is a buyer in ordinary course of business takes free of a security interest created by the seller, even if the buyer is aware of the existence of the security interest. Now, a buyer in ordinary course of business is a person that buys goods in good faith and in the ordinary course from a person in the business of selling goods of that kind. So, bottom line is, if the purchase is if the purchase is made by a buyer in ordinary course, the secured party cannot enforce its security interest against the goods that were purchased anymore. They are left to go against the proceeds in the hands of the debtor. And this makes sense because where it's most applicable are in retail sales, either consumer retail or in a commercial retail. For example, you don't want somebody to walk into an electronics store, buy a big screen color TV, and later have the bank show up at their door saying, we want you to either pay us for the TV again or we take the TV. It's a way of protecting the buyers in these cases because a buyer expects to take free of a security interest. And the same would apply even to heavy equipment. ABC Equipment Company might sell bulldozers in ordinary course of business to construction companies. That's fine. That still would provide buyer in ordinary course protection. So what happens in transfer of collateral? Well, if the debtor transfers collateral without the secured party's knowledge or authorization, actually just without authorization, that's going to be a problem. If the buyer is a buyer in ordinary course, not much the secured party can do about it. So if the buyer is a buyer in ordinary course of business, if that's a transferee, then the buyer or the transferee takes free of the security interest. There's nothing the secured party can do. They can only go against the proceeds of the transfer. Now, if the buyer or if the transferee is not a buyer in ordinary course, then the secured party remains perfected and retains its priority without any further action. It does not need to file a financing statement under Article 9 to remain perfected, even if the transferee's name is different from the name of the original secured or original debtor. And unless, of course, it's a transfer between related entities. So if it's a transfer to a successor in interest, then you've got the new debtor rules applying, new debtor becoming bound. So how does this play out in the courts? Again, the secured party really doesn't have to take any action. There are plenty of cases out there. One is the recent one, 4-County Bank versus Tidewater. Here the bank financed 2 pieces of equipment for the debtor. Debtor sold equipment, the equipment to Tidewater Equipment without the bank's knowledge or consent. Tidewater didn't do a UCC search, and it later resold the equipment to a third party. After Tidewater took possession and resold the equipment, the bank's financing statement lapsed, and the bank later refiled the financing statement, and the debtor defaulted. The bank sued Tidewater to recover the value of the equipment. The court found in favor of Tidewater because on the lapse of the security interest, it was deemed never to have been perfected against a purchaser of the collateral for value. The purchaser in this case was a secured party, or I'm sorry, the actual purchaser, and they took without knowledge at the time. The court didn't find it significant, apparently, that they didn't conduct a UCC search, and because the secured party was unperfected, the court held that Tidewater won, and the bank could only go after the debtor, which of course was in bankruptcy at that time. Teague v. Taylor. What happened here is Caterpillar financed the debtor's purchase of a multi-terrain loader and got obtained a perfected security interest in that piece of equipment. Later, the debtor sold the loader to a fellow named Teague without Caterpillar's knowledge or consent. Teague claimed that the debtor told him there was no lien on the loader, but Teague didn't otherwise investigate it. The debtor filed for bankruptcy, and Caterpillar sought to recover the loader from Teague, and Teague refused to turn it over. Teague claimed he did not know of Caterpillar's security interest at the time of purchase, and the court concluded that Teague purchased the loader subject to Caterpillar's security interest even if he didn't know about it. The court noted that a buyer in ordinary course takes free of the security interest. However, buyer in ordinary course protection did not apply here because the seller was not engaged in selling heavy equipment. It was a construction company. The court noted that companies that just because a company sells equipment from time to time doesn't mean that they're engaged in selling goods of that kind. It cited a case where companies sold obsolete equipment from time to time, and the court had held that that did not make them a seller engaged in selling goods of that kind. So because Teague couldn't prove he was a buyer in ordinary course, the court found in favor of Caterpillar. So when it comes to transfer of collateral, it's important to bear a few things in mind. It is not necessary to amend the financing statement unless the transferee is located in a different state. The secured party can amend the financing statement, but filing a debtor name change may result in loss of priority, so that can be risky. If an amendment must be filed, if the secured party feels it must file an amendment to add the name of the transferee, do it as a collateral add, do it as a debtor add, not as a debtor change. If the transferee is a successor in interest to the transferor, probably a good idea to follow the rules for a new debtor becoming bound by the security agreement rather than just assuming that they can leave it unamended, the financing statement. And beware of a change in the governing law. If the transferee is in a different state under 9307 than the transferor, it'd be a good idea to file a new financing statement in the new state. So those are the concerns of the transfer of collateral. I want to wrap up with a short discussion about how to identify these post-closing changes. There are some ways to track debtors, but it's not always easy because some types of debtors may not leave a public record trail. And the burden is on the secured party to do this tracking because they are held strictly accountable for compliance one way or the other. So how does one track post-closing changes? One is to make sure that all of the secured party's personnel are aware that certain things, that if they learn certain things, they better alert the right people within the organization. So, for example, if a customer service at a financial institution gets a call from a debtor saying, "Hey, I'm moving from Wisconsin to Illinois, and I want you to start sending my loan statements to Illinois," that's something that maybe they got to notify the loan doc people in the bank that they have to investigate that a little further. So it's important to make people aware that these are issues. A lender, a secured party, can actually do its own public records tracking. That requires going to a state website and doing a search on the debtor if it's a registered organization or a company that's registered to do business in the state. That's a non-registered organization that nevertheless maintains its status with the state. It can be searched by going to the Secretary of State and doing it on a regular basis, maybe every 60 to 90 days, to identify organization changes. The problem with that is that can take a great deal of time and resources, personnel resources, to do, and it's not all that reliable. And then there are third-party tracking systems that are automated, computerized. CSC has such a system, and I'm sure our competitors do too. But this allows for automatic tracking, and any time a change at the Secretary of State occurs, with the documents on file there, and an alert goes out to the secured party. There are, however, some tracking limitations. With individuals, the driver's license is not a public record. So the only way a secured party can track debtor name changes is that, well, really they're at the mercy of the debtor to come and tell them when there's been a change to the driver's license. And not all of these can really be tracked. Transfers of collateral might be different to track. Changes to name or location of certain types of entities may be difficult to track. The best practice is to stay in contact with debtors and identify any type of changes on a regular basis so that the secured party has time to act. But with that, I want to wrap up the presentation. Anu, I want to go back to you for Q&A.
Thank you, Paul. We definitely have some questions coming in. So the presentation was great, and we will now open up the Q&A session. Also on the screen, we have one last question for you. Would you like to be contacted by a UCC specialist? So we've got that up on the screen for you to make your selections. And also, just as a reminder, you can download a copy of today's materials from the handouts box. If you'd like to see what other webinars CSC offers, click on the free education webinars link in the Join Us for More box. Now let's take some questions from the audience. Jeffrey writes in, Paul, hi Paul, do you have suggestions for how to monitor for debtor name changes to best practices?
Yeah, as I said, there are either automated tracking tools which work best with registered organizations, LLCs and corporations, or a secured party can manually check the status of each of these entities with the Secretary of State on a periodic basis. For other types of entities and individuals, the only way to track it is going to be through personal contact with the debtor. I mean, you can have the debtor make all sorts of reps and warranties and have a covenant that they'll notify the secured party immediately upon a name change, but they don't remember to do that. And even so, they don't always recognize that a name change event has occurred. So you can track what's possible, which is the registered organizations, effectively, and the rest of it just requires luck and regular contact with the debtor.
All right. Thank you. Margaret wrote in, what happens if the creditor did not know the debtor has changed the name within the 4-month time frame?
The creditor is still held accountable for filing the financing statement. If they don't, they become unperfected, regardless of whether they had knowledge. So it's unfortunately the creditor is just going to be out of luck.
Okay. Yumi wrote in, if the name change occurred within 6 months before the lapse date, is it acceptable to file the continuation with the new debtor name without filing the amendment for the name change?
Well, the debtor name on an amendment is not an amendment to change the debtor name or add the debtor name. It's common practice to put debtor names on continuation statements, but unless the party change debtor box is checked and change or add is checked and all the new information provided, it's not a debtor name amendment. It's only a continuation, and the secured party will still become unperfected in the after acquired collateral.
Okay. John is asking, do we have to also change the security agreement to reflect the change in the UCC1? I thought we could perfect the collateral with the security agreement.
Yeah, I'm gonna leave that to other legal counsel, I guess. My scope of expertise deals with financing statements, although there is no requirement that the name on the financing statement match the name on the security agreement or vice versa. In fact, sometimes the name on a security agreement will not be sufficient as the name of the debtor for purposes of a financing statement. And I'm probably opening in a new can of worms here, but generally the security agreement would probably remain okay, but I'm not comfortable standing by and saying don't worry about it. I recommend that you consult with legal counsel that deals with drafting the security agreements to know that one for sure. I'm going to stay focused on the financing statement side of it.
Thank you. Kamini wrote in, if you have filed a blanket on a debtor and the debtor acquires another entity, is there any action that needs to be taken besides reviewing a UCC search on the acquired entity?
Generally not, because the secured creditor of the acquiring entity, there isn't anything that they need to change. It's only the creditor of the original debtor that's being acquired that is going to have to take action.
All right, let's just get a couple more in, and then as a reminder, if we did not get to your question online, we will get back to you after the webinar. Marcy wrote in, Paul, what effect does a restatement of collateral have on priority?
It depends on what the restatement does. A restatement of collateral is intended to replace all prior collateral descriptions, and it will have a priority, the effect priority-wise of maintaining priority of any collateral that was covered on prior collateral descriptions. It won't change the priority on those. But if the restated collateral description adds collateral that was not already within the scope of prior collateral descriptions, it will only be effective for priority from the date the amendment was filed. So it depends on the specific description involved.
Okay, Jessica is asking, regarding debtors, when filing an amendment for an address change, is it better to file a change or add the new address?
For an address, it's you can only do it as a change. If you do it as an add, you have to provide the debtor name again, not just the address, and then it would be added as an additional debtor. And there's actually at least one state that will reject if you try and add a debtor name that already exists on the financing statement. They're not legally authorized to reject for that reason, but they do because they're afraid it'll confuse the record.
Okay, Sandy's asking if you can briefly review the holder in due course rules.
Holder in due course? Well, I really can't within the scope of this presentation, maybe in another presentation.
I think that is all the time we have for today, and I will get these questions over to Paul, so we will get back to all of you shortly. If we didn't get to you, feel free to reach out to us as well. Thank you to everyone who joined us today. We hope to see you next time.